Government use and acquisition. The government has the power to use certain inventions that are covered in a patent. This could be done for the purposes of the government. The central government, the state government, or a government undertaking can initiate these proceedings. The meaning of government use has been defined as something that is made, used, exercised, or vented for the purpose of the government. So if there is an invention that is being made, used, exercised, or vended for the purposes of the government, and that invention is covered by a patent, then the government can seek the patent for government use, or it can also acquire the invention. Just how the government has the power to acquire land in certain circumstances, the government also has the power to acquire patent, which is an intellectual property. Now, use of a medicine or drugs under section 47 is regarded as one such instance of a use. The procedure for the government to acquire requires the payment of royalty to the patentee. So if the government is going to use or acquire an invention, then royalty has to be paid. Now, however, no royalty is required to be paid if it is tested on behalf of the government before the priority date. Now, the priority date is the date on which the patent application is filed or the priority document is lodged. If the government tested the invention before the priority date, then there is no liability on the government to pay royalty. This is because the government tested it before the patent crystallized or before an application for a patent was even filed. Now, if it is not tested on behalf of the government, then for all the use after the grant of the patent, the government is liable to pay royalty to the patentee. Now, this requires authorization by the government. The government can authorize before or after the grant any person to use the invention, and the government shall also notify the patentee about such use. Now, third-party rights are also factored in when the government uses the invention. A third-party agreement shall not restrict the use of the invention by the government. For instance, the patentee has an agreement with a licensee that the patentee will not give this to anybody else but the licensee. Such a third-party arrangement will not affect or restrict the use of the government. But if the third party is a beneficiary who is entitled to receiving the payment, then such arrangements can be made for making payments to the third party. There can be no copyright infringement on government use, and compensation for government use is something that will be given. Acquisition of an invention. The government can acquire invention for public purposes. It shall publish a notification in the official gazette, and notice shall be given to people having interest in the application. Compensation shall also be paid. In case of default of payment of compensation, the issue shall be decided by the High Court.